deliberate on both the adoption of the environmental documents and the adoption of the question of the adoption of the project itself. Before we do that, I see that we're graced this morning by the presence of Fresno's mayor, the Honorable Ashley Swearingen, and thank you very much, Mayor, for providing these facilities to us today, and thank you so much. With that, Mr. Morales, I don't know how you'd like to have the staff proceed this morning, but I'll ask you to turn it. Oh, and before I do, I have an important announcement, and everybody should thank the mayor because, once again, parking meters are relaxed today, whatever that means. And so, yes. Thank you, Mayor, and the City of Fresno for helping to accommodate public participation in this. So. Nobody should have to run out and feed the parking meters. Yesterday we had some of the board members doing that, so I think we're good. Mr. Morales.
Thank you, Mr. Chairman. Last night, after the conclusion of the comment period, I identified a number of the key themes that had come out of the comments that we felt it was important to report back on to the board this morning for discussion and deliberation. And we have those prepared for you, and then obviously the board can ask any additional questions that it has of those issues, but what we'll do is walk through the specific things that we identified last night and then turn it to the board for your deliberation. So we'll start with Diana on some of the specific impacts that were identified yesterday.
Okay. Good morning, Ms. Gomez.
Good morning, Chairman Richards, board members. So yesterday there was several issues that were brought up. I'm going to start before I go into the staff response to some of the issues. I want to talk about one issue that was raised, which the appraisal process. That individual's property is located within the Merced to Fresno section. So I'm going to talk a little bit about our appraisal process before I go into some of the other details related to the Fresno to Bakersfield document. So it was requested. So in terms of the appraisal process, so what happens is we send out notice of decisions to appraise. It also instructs the property owner that we'd like to meet with them to talk to them about their property, their operation, exactly what happens specifically. In this case, it was a business, how the business operates. And then once that information is gathered, the appraiser goes off and puts together an appraisal. In some cases, when the property owner chooses not to meet with the appraiser, then the appraiser determines the method that they're going to use to come up with that appraisal based on information that they've been able to gather through city documents or other information that may be on record about that business. At that time, once the appraisal is completed, it goes through a series of review processes within the authority, within DGS. And then once we get an approved appraisal, we then reach out to that property owner and let them know that we'd like to come out and provide them with a first written offer. At that time, we provide to the property owner the appraisal, the method that was used to come to that dollar amount, and answer any questions, and also provide them with their rights. And one of those rights is that anybody can choose to have their own appraiser do another appraisal, and we pay for that up to a maximum of $5,000. Now, yesterday the gentleman mentioned that, well, I don't want to get my own appraisal. I want you to fix your appraisal, and that is part of the process, part of the negotiation process. So that at that time, the property owner has the right to tell us, you did not include, this portion of the property. You did not include this piece of the operations. And so then we take that into consideration, and we can then go back and revise the appraisal and then come back out. And so it's at that time, once we present the first written offer, that's where, in a sense, the negotiation starts. So that's kind of a summary of the appraisal process.
Let me just, Mr. Schenk may have a question, but just to clarify, our entire right-of-way process, so the entire process of identifying parcels and then going through the process of ultimately acquiring them is governed under federal and state laws that are the same laws and rules that apply to every other public agency. So we're not inventing a new process here. And we have, as part of, so the things that Diana talked about are all steps that are common to the public acquisition process. And in addition, it's not just within the authority. We have to go through the State Public Works Board, as well as the State Department of General Services to get approvals for appraised values, to be able to make offers, and to go through the entire process. So it's, I just want to reinforce and make sure the board understands that that process is one that is long established, and we are following the same procedures that any other public agency would.
Ms. Shank, did you have a
On
comment?
the appraisal, Diana, where do we come up with the $5,000 reimbursement? Having just gone through some appraisals myself, I think the gentleman was correct. It really is a lot more than five, but is that, where did that number come from?
I believe that's a standard fee that is used, other state agencies use that same fee. Or Tom, if you'd like to.
Ms. Shank, it's a state law.
By law?
Yes.
Okay, so
And as Ms. Gomez pointed out, throughout the process, property owners retain their rights to not only see information, but to take whatever course they feel is necessary should they not agree with the values.
thank you.
Just one last thing on this before we move on to the comments on the CEQA documents itself. I appreciate Ms. Gomez talking about the appraisal process because Mr. Aronian raised that question yesterday. Recently, I had the occasion to question the staff about how we're doing on the land acquisition in the Merced to Fresno area. And one of the things I was very gratified to hear is that at least so far, less than 10% of the interactions with landowners are even taking any step towards eminent domain. And if you look at a comparator with Caltrans, on average 23% of the land that they acquire when Caltrans does a road expansion is through the eminent domain process. Right now, we're running at about 90% land acquisition through bilateral agreements with landowners. And so I think in terms of one marker of the sensitivity with which the staff has been proceeding in working with affected landowners, that certainly gave me some comfort. We'd like that number to be 100%, but I think that it shows that we're off to a pretty good start. So that's to commend Mr. Morales and the staff for the way that they've been approaching this.
Okay, now I will talk about the issues that were raised yesterday. So the team deliberated late into the morning, so what somebody told me it was morning, following the board meeting yesterday, and to come up with some key issues that were, to address some of the key issues that were raised. Several of the members of the team will be providing the findings, and I will start with those that dealt with specific impacts to properties. So yesterday, several property owners raised specific questions on impacts to their property and our team is prepared to provide an update. For the past year and a half, we have met with owners along, both alignments, whether it was a preferred alignment or not the preferred alignment. And we will continue to meet with those property owners. We've met with them at our request and in some cases their request. So we are continue to meet with them to address their request. The first one was the Machado Dairy. And when we had met with Kings County, and Chairman, you were there, they had asked about the dairies and the impacts of the dairies, and did we actually analyze all of the dairy impacts. So dairy impacts have been extensively studied through impacts that impact the agricultural as well as the economic impacts to the dairy industry. In most instances, dairy impacts to the dairy operations may be limited to affluent fields and supporting irrigation facilities. So in some cases, the county had mentioned, well, you're not impacting the dairy, but you're impacting their affluent ponds, which may be 2 miles away. And what we will be allowing is, and this is one of the questions that kept coming up, is what will be allowed under our right-of-way. We will be installing irrigation utility crosses below our right-of-way, and so the transmission of dairy effluents may be perpetuated to several parcel remnants. So this is one of the mitigation measures that we will be offering. This will significantly reduce the loss of affluent field acreages. So in this case of that dairy, we are impacting their affluent field. As far as permitting was concerned, because this was another issue that was raised at the Kings County meeting, The authority will work individually with each impacted dairy to help them acquire new or revised permits related to their operations. This practice is described in the agricultural section project of the design features. The other one, Baker's Commodity, was not here, but a person brought up the issue of Baker's Commodity. We have met with the management of Baker's Commodity in the plant in Hanford on several occasions. We actually met with them 2 weeks ago to discuss our response to their comments. And we discussed the potential project impacts and methods to mitigate those impacts. Baker's Commodities has agreed that the authority can reconfigure facilities on their property so that the project will not impact their operation and the plant can remain in operation at its existing location. The other was the Cooper Brothers Farming operation east of Corcoran. Their comment was overcrossings at Avenue 144 and State Route 43 will create substantial impacts to their farming operation. The overcrossing referred are associated with the BNSF through alignment, which is not a preferred alignment. The recommended alternative is the Corcoran bypass, which does not require these overcrossings. As a result, our project will only require an 80-foot to 100-foot strip through their property. Further, because the alignment will be elevated through part of their property, they will be able to access both sides of the alignment under the viaduct. We have met with the Coopers and explained that overcrossing would not be required with the preferred alignment. The other comment was about Avenue 144, which is the main commute route to Corcoran State Prison, and that closing 144 would impact traffic in that area. We will not be closing Avenue 144 because our facility will be on a viaduct. So it is not going to be closed as part of the Corcoran bypass. The other was Hanson Farms. Why are there 3 overcrossings in 3 miles? In our response, in the initial design phase, the number of overcrossings is determined by traffic volumes on individual roads. As a project progresses through the final design phase, local jurisdictions may allow for the omission of overcrossings that they believe are unnecessary. His other comment was, our current land values accurately reflected in the project budget. The cost of mitigation and property acquisition is included in the cost estimate for the Fresno to Bakersfield section. It is summarized in Chapter 5 of the document. All cost estimates are developed in a 2010 base year dollars, then escalated per the actual and projected escalation rates provided by KPMG, a U.S. audit, tax, and advisory services. The cost estimates for Fresno to Bakersfield section is consistent with this methodology. The other was PFF Farms, which is Hormel. Avenue 120 overcrossingly significantly impacts Hormel's effluent disposal field. That was their comment. We have met with Hormel Foods 3 times over the last year, and we understand the issues described by the operations manager. We have also met with Tulare County to discuss options for modifying the plant overcrossing to minimize economic harm to this business related to their displaced disposal area. Options to modify the plant overcrossing can be done within the environmental footprint evaluated in the document. The county is supportive of these efforts, and we will continue to work with Hormel and Tulare County. Any loss of disposal area will be compensated at fair market value. Their other comment was that our main line impacts their feed mill located adjacent to the BNSF tracks, south of Avenue 110. The alignment does result in a total take of that subject facility. As indicated in Volume 4 responses to comments, we will work with Hormel to ensure that the owner receives just compensation for project damages. Furthermore, authority staff has committed to assist them in finding a site for relocation of the mill. The authority has established a track record here in Fresno County with successfully assisting business relocations. We believe we can continue these efforts as the project moves south into Kings County, Tulare, and Kern County. The final one is the Kit Carson School District. The relocations within the Kit Carson Elementary School District will result in the potential loss of an estimated 9 students out of 448 enrolled. The school is outside the 1/2 mile study area for schools and is not within the area subject to impacts with our proposed project. We did meet with the school district on March 9th in 2011 and soon thereafter hosted a public information meeting located on the Kit Carson campus in May of 2011. That drew nearly 100 individuals. In addition, Kit Carson has been notified and provided copies of the materials upon release of the draft document, the revised draft document, and the final document. Those are the individual impacts to property owners. Now I'm going to turn it over to Mark, who will address some of the technical issues.
Before you do, let me just ask board members if they have any questions of Ms. Gomez. I just have to say that was an encouraging report, I think, in terms of context for some of those impacts. But in any case, other board members' questions? Vice Chair Richards.
Thank you, Mr. Chairman. Diana, I just wanted to clarify one thing. From the very outset, as we've traveled through the southern part of the valley with regard specifically to the dairies, and as Mr. Machado had indicated yesterday, I think he was on the first trip that I had along with the Fukudas. One of the big issues, it's always been stated, is not only the impacts to their property, but the ability to have their businesses relicensed. So I think you mentioned that briefly, if I heard that correctly a while ago. That was one of the real challenges. So even if we're dealing with their affluent, the concern that they had raised to us with regards to having their operations relicensed, did you address that, or can you address that in your comments?
And just to supplement that, my understanding is that even if they have their effluent field, if they lose acreage, they may be limited under other regulations from having a number of head of cattle based on the land that they have, right? I think that's what you're referring to.
Yeah. Well, I'm referring to what had been stated to us also, is it would just literally shut their operations down. I think that's clearly what we're trying to avoid here.
Right. And we have met with some of the regulatory agencies around the dairies to try to figure out how we can minimize those impacts. And so we feel confident that we will be able to do that in working with those regulatory agencies and ensuring that their permits are reissued or modified.
Okay, great. And obviously you will stay in close contact with those dairy farmers who are being impacted.
Right. And not only with the dairy, anybody along the alignment. Now that we have the preferred alignment, we are more than happy to come out and meet with them and discuss the impacts and determine how we can minimize those.
Okay. And especially those whose businesses would be impacted by reducing productivity or eliminating any operations to the extent that they can't or they don't have licensing for some period of time.
That's correct.
Okay, great. Thanks, Diane.
Keep the mic close if you're going to talk.
Just a brief follow-up to that. These kind of operational impacts are very critical, obviously, to looking at these. And I think we heard comments yesterday from particularly farmers in Wasco and Shafter in those areas about how we had worked together with them to address very much those kind of issues, and how both alignment decisions and other issues were taken into account to deal with those. So it's not just about looking at the physical impact to the properties or the physical effects, but also the operational needs as they go forward. So that has been dealt with here, but is an ongoing part of the process as well.
Other questions? Okay.
Thank you.
Thank you, Ms. Gomez. Mr. McLaughlin, good morning. Yeah, he's still taller and he still has
Yes,
less
I am. I'm going to work on that. Good morning, Mr. Chairman and board members. Mark
And Mark, if you can try to speak as closely to the microphone as possible.
Mark McLaughlin, Director of Environmental Services for the Authority. I'm going to follow up Diana's topics with one topic, the Fresno Chinatown cultural resource questions yesterday. I also wanted to make sure the board members were provided our staff response, was our summary of what we're providing you today. We also have that back in the outside foyer for the public to view also. First off, the Fresno Chinatown section of the project is part of the original alignment and overlaps between the previously approved Merced Fresno to Fresno section of the project and the Fresno to Bakersfield section. Both of these documents look at the Fresno station and provide context to continuity and the analysis. For the cultural resources, the Fresno-Bakersfield documents referred the reader to the prior Merced-Fresno analysis. The authority, we've also structured its compliance with Section 106 with the National Historic Preservation Act, so it will be in compliance to the section where impacts will occur. In this case, the Merced to Fresno section, not in the Fresno to Bakersfield section where the impacts information is provided for context and that continuity. For the Merced to Fresno section 106 process, we have reached out to communicate with the Chinatown Revitalization Organization during the process and invited its organization to be part of our memorandum of agreement for the Merced-Fresno section. Until this date, we have not got a response from this organization. For the Merced to Fresno section 106 process, the authority has continued to keep the Chinatown Revitalization Organization informed regardless and will continue to work with them through the process. So those conclude my comments on the Chinatown section.
Questions on that? Ms. Perez-Estelano, and they want us to speak closely into the microphone.
Of course, I'm fine. I'm fine to scream into it. Mark, in terms of reaching out to the group that was represented yesterday, we're referring to the same group of the young man who came and said, you know, we're available, but we haven't had any contact with the authority. Is that correct?
I'm not sure that's correct. Maybe Diana could comment on that.
Same person?
She's been in the personal meetings with them.
I think, yeah, it was Mr. Brownstein, if my memory serves me right.
I didn't write his name down. I just wrote his comments down.
Yep.
Yeah.
Was that the same person, Diana?
Yeah, it was the same person, but we have met with them more than once, and we did participate in a forum that they put together, a panel, and several of us participated in that effort. We've also met with them regarding Chinatown and, you know, what it means to them, and so we have been keeping them informed of what we've been doing in Chinatown and providing them the opportunity to comment on every step, you know, before we started the archaeological digs, and so we did give them that opportunity.
So there's just a misunderstanding or something between his experience and what our efforts have been?
I mean, if you want to call it a misunderstanding, but I'm not sure if he understands that that section was covered under the Merced to Fresno environmental document.
Because it is important, and the Chinatown history here in Fresno is critically important to the work that we do. And obviously, it is I think for me, one of the most important parts of the early work that we've been doing on the CEQA.
And the city of Fresno has also participated in every one of those meetings and the event as well. So the city has been there and provided their concerns, their input, and we feel that we've been addressing them adequately.
Thank you.
Thank you.
Thank you. I'd like to introduce Andrew Bain of the program management team. From a technical perspective, I want to let the board members know that we have technical expertise for any questions you may have that we may not be able to answer. So, Andrew Bain.
Morning, Chairman Richard, board members. I'm Andrew Bain. I'm with the program management team, environmental manager. I will be discussing two topics today that were brought up in yesterday's meeting. The first is environmental justice. A person testified that there were new significant impacts identified in Chapter 6 of the Environmental Impact Report, Environmental Impact Statement. This is correct that new text was provided in Chapter 6, but no new significant impacts were identified. Chapter 6 is the significant and unavoidable impacts caused by the project. The Federal Railroad Administration is responsible for evaluating the project for environmental justice concerns, and between the revised draft and the final, in response to comments on the environmental justice section, it was reorganized in Chapter 3 in order to more clearly define what environmental justice communities are receiving the significant impacts. As a result of that reorganization to clarify the impacts, the conclusions were brought from Chapter 3 into Chapter 6. So while, yes, It's new text. There are not new impacts. The impacts and the mitigation for those impacts are identified in Chapter 3. So really, Chapter 6 is just a modification to the text to reflect the clarification in Chapter 3. I hope that's clear. It's kind of confusing sometimes. Also related to environmental justice, a concern was brought up about census data and how it was used. The 2000 census data was used to draw a baseline for environmental justice communities. A half-mile buffer was drawn from the alignment and station areas, and the 2000 census data were used to identify what we thought were environmental justice communities. Given that the project started in 2009, before the 2010 data were available, those maps were sent to the local experts along the alignment and near the stations, and we asked them to tell us, are these environmental justice communities? Can you give us input on what environmental justice communities we're not including or we're missing? That information was provided back. Our maps were revised in order to identify those environmental justice communities so that we could compare the impacts on those communities against the impacts on the reference communities. So it was slightly incorrect that we did not apply, or that it was a misunderstanding about how we applied the 2000 data in defining the environmental justice communities. One other point of clarification about the census data that you should understand between the revised draft and the final. Census data was not used for the evaluation of noise impacts and displacements. Those were conducted on a parcel-by-parcel basis. So where we have actual physical impacts, we have a project-level evaluation of those impacts. Are there any questions about socioeconomics, environmental justice?
Yes, Mr. Frank.
Yes, I appreciate your comments, and I was concerned about some of the testimony that we received yesterday. I think environmental justice is an enormously important concern as we go forward with this project, and obviously those problems have been endemic here in the Valley for many years before we got here, and I'm satisfied based on the analysis in the document and elsewhere that hopefully, as a result of this high-speed rail project, that we will be part of the solution to that long-term problem rather than exacerbating it. I don't think that's the case, so I want to commend staff for their sensitivity to that issue and what they're doing. Prospectively, you mentioned census tracts, and that reminded me that one of our sister state agencies, the California Environmental Protection Agency, has really done some pioneering work here in terms of looking at environmental justice inequities in communities, and their product, CalEnviroScreen, has just come up with a modification to really refine the data which had previously been done throughout the state by zip codes and reduce it to census tracts. And while it's still in draft form, that revised version, I think, is a very important tool that we and other state agencies can and should use to identify the communities that are most sensitive, both here in the Central Valley and elsewhere along the proposed right-of-way.
Thank you.
Ms. Perez-Estalon.
Good morning. I'm kind of confused. So the project was initiated in 2009, and so that's why 2000 census data was used initially.
As a baseline.
As a baseline, correct. But now that the project has advanced, and was there an opportunity to update the data with the 2010 census?
The data was updated.
It was updated.
As it became available.
Right.
Data from the California Employment Development Department, the Department of Finance, and the American Community Survey single-year estimates were applied to project what the census data would be. And when we look at recently published demographic and economic reports, it corroborates the projections that were used for the analysis of impacts.
Because the communities that would have greatest impact, economic impact, you would have seen it more clearly in the 2010 data after the recession.
Right, and then also it was direct communication with the experts in the local areas, so that the numbers were backed up by people that are in the communities.
And I understand that the census information kind of was rolling, that you
It
got
rolls.
some numbers and then later you got other numbers, and so
Yes.
it's staggered. And then I would echo my colleague that we need to actually use the tools that are being developed by the state in terms of the EnviroScreen. It's also my understanding that there may be some interest in linking potential funding with red zones on the EnviroScreen, that there is an interest to direct efforts to focus on those communities. So if that's a tool that the state may be using, I suggest highly that we actually jump in front of that moving train. Because it is, I think there's, I know, bad joke at 10 a.m. But it is something I think that the state is invested in leveraging. So I echo Mr. Frank.
Thank you. Other questions? Okay.
Thank you.
Mr. Bain, thank you.
Good morning, Chair Richard and board members and CEO Morales. Jim Andrew, Assistant Chief Counsel for the Authority, and I'm going to talk about a couple of items, but I need Andrew for one of them. So one of the issues raised yesterday was about, from the City of Bakersfield, mentioned some 4F and 6F issues in the City of Bakersfield. Andrew's going to talk a little bit about the substance behind them, and then I'll make a comment about the sort of legal technicality of those issues that Bakersfield raised.
Mr. Andrew, I think we know what 4F and 6F refer to, but maybe for the audience you could just take a second and make sure that everybody understands what those are.
Okay, Section 4F is a federal regulation that is for the Department of Transportation Act that limits the federal transportation agencies from impacting parks, cultural resources, and wildlife refuges.
Yes.
So if there are alternatives that would...
There may be some wildlife refugees out there, but mostly they like to stay in the refuges, I think. Right. Okay.
So if there is a reasonable alternative that avoids impacting those three categories, then the transportation agency is compelled to select that alternative. In Bakersfield, there are several Section 4F properties. These are common to all three alignments in Bakersfield, and so there is no alternative to avoid them. Bakersfield continues to say that we're having an impact on a 6F property. 6F refers to money that's given in a grant form to public agencies for developing parks. And the City of Bakersfield did receive Section 4F grants, one in 1989 and another in 1990.
6F.
6F grants in 89 and 90. They used these funds to build Yokit's Park, which is a small picnic area type park in the Kern River Parkway. It's distinct. It has a property, or not a property, it has an area boundary to it. It was improved and it's maintained. This park facility is about 1,200 feet from the closest alignment. We do not impact that park. The city has not provided us with any evidence that it has any other Section 6F park in that area. So.
Okay.
And I didn't want to open with this issue because, of course, it's important, but these are federal issues that are not actually legally, technically relevant to the CEQA adequacy that's before you today. They are federal laws that govern the FRA's approval of the EIS and the record of decision that they will be making sometime in the near future. But we have dealt with them, as Mr. Bain talked about, but they are strictly federal issues and deal with the adequacy of their process, not the CEQA process that's really before you here today. So I want to talk about the remaining items, and just to remind the board and the public, we're talking largely from the staff prepared response document. I believe all the board members have that Mr. McLaughlin mentioned, and I don't know if he mentioned it's also copies are on the back table for the public as well. I'm not sure if he mentioned that, but I wanted to be sure to let the public know that they're in the back document. And
it's on the website? Okay.
I'm not sure if it has hit yet, but it's in the process. So I wanted to address 4 remaining issues. The first is the issue of valley fever that was raised yesterday in a few of the public comments. Valley fever is related to fugitive dust emissions. And the environmental document deals with fugitive dust and includes measures that are recommended by the California Department of Public Health to reduce the fugitive dust, because it's a fugitive dust that leads to or can lead to valley fever. So it's really a dust that is the issue, and the EIR addresses dust by having specific design features and mitigation measures to deal with reducing the amount of dust, and it comes in a couple of different ways. We have suspending construction when wind speeds exceed 25 miles an hour, keeping construction areas watered to limit the fugitive dust, washing trucks and equipment as they're leaving. And I also mentioned that I think it came up yesterday that we have a air quality mitigation measure which would be entering into an agreement with the San Joaquin Valley Air Pollution Control District to offset the emissions from the project to a net zero level, and that includes fugitive dust that would be generated by earth moving. So, and the actually draft agreement for the first construction segment that we're working for now, construction package 1A and 1B, actually includes language that says the district shall use reasonable efforts to prioritize owners and operations of pollution source equipment that will lead to these offsets located as close as possible geographically to the actual areas of the construction. So if there's a diesel irrigation pump that's going to get replaced right near the construction line, that'll be prioritized over a diesel irrigation pump that's 30 miles away from the construction site. So there will be an offset of a fugitive dust through the VERA agreement, and there's a prioritization to do it in proximity to the actual construction. We also are going to be recommending, or are recommending, inclusion of a few additional protection measures for construction workers, and this again comes directly from the California Department of Public Health to add 4 additional measures, and we can go through that in a little bit more detail when we get to the project approval here in a few minutes. But we have a recommending inclusion of 4 additional measures, and they're on page 1 of the staff response at the bottom of that first page. And there's already a construction and health and safety plan required in our health and safety portion of the EIR chapter 3.11, safety and security. And what we'll be recommending is revising the design feature to require the 4 items mentioned there to focus on protection for workers who are actually going to be working on the project. The next item I wanted to talk about is Bakersfield's suggestion or request that there be an inclusion in the board's approval resolution, and we'll get to that later, approval resolution of the project, specifying that the authority will not approve any project south of 7th Standard Road without 60-day notification, a written notification to the city of Bakersfield, and just wanted to point out that staff is supportive of that inclusion, and we can go through how that would get included later. The third item I wanted to mention is the issues raised yesterday about this volume 6 of the EIR and the letters that were inadvertently omitted from the final EIR when it was published on the website on April 18th. And to some background is that CEQA actually does not require release to the public of an issuance of the final EIR. The CEQA requires, as a strict matter, that the comments are responded to in writing for the agency and the board's information and purposes, and that public agencies who submit a comment letter, receive a proposed response to their comment a minimum of 10 days prior to the board certification of the EIR. That's the minimum CEQA requirement, and that requirement was met by the publication of the EIR, final EIR, on April 18th, and then there were about 35 letters that were inadvertently not included in that publication on the 18th. 2 of those letters were from public agencies, and those were sent out via overnight mail to those agencies the week of the 21st of April, and they were sent out on the 24th to meet that 10-day requirement. So as a matter of CEQA requirement, we are fully in compliance with everything that needed to be done in terms of the final EIR. The detail as to what happened is in your response document. It was just a clerical error in that there were, when letters were received, a received stamp came in after the end of the comment period. Those were inadvertent, even though they were postmarked within the comment period. Those 35 letters that were received after the comment period, even though postmarked before, were just inadvertently, there was a line drawn inadvertently to put those on the late side of the line, and they should have been on the on-time side of the line, and that's why they got omitted from the April 18th notification of the EIR. But as soon as we discovered that issue, we corrected it by development of this Volume 6, which was completed on May 2nd, and the board, I think, was sent an email notifying of its availability, and it was posted on the website. And the last item I wanted to talk about is some of the comment that came up yesterday about inadequate time to review the final EIR. And I think it goes back to what I said a moment ago, which is that there is no actual, strictly speaking, a legal obligation under CEQA for a public review comment period time on the final EIR. It is, the comment period is at the draft EIR stages, and then the staff's obligation to respond in writing is to round out the information in the final EIR for the board's consideration and information, so the board is adequately informed of the potential environmental consequences of the project should the board or the lead agency of governing body decide to adopt the project. There is no review comment period time on the final EIR. As I mentioned, this is the obligation to issue the letters to public agencies 10 days before. So the authority, by publishing and widely notifying the public of the availability of the document on April 18th and sending hard copies throughout the libraries in the Central Valley, went above the requirement of CEQA.
Okay. Questions or comments? Ms. Shelby? Flip that up.
Can you hear me now?
Yes.
Okay. Thank you very much for your in-depth analysis and explanations of what's going on. I was particularly...
I'm sorry. Can people hear?
Can you hear me?
Okay.
Yeah?
Okay. I'm sorry. Go ahead.
I was particularly concerned about the valley fever, having spent some time here and recognizing it, particularly that children suffer from a lot of respiratory problems already here. And I just wondered, I read a little bit about it, and it seems that when it gets worse when it git's wet, that the whatever it is in the dust, that when it gets wet, and I don't know enough about this to know that if it's when it gets into the lungs is when it gets wet, or when we wet it, that the problem comes up. So I wanted to ask you about that and just see if I could understand that a little bit better. And then my second question on it just has to do with, it sounds like you're doing really good and careful work with the people who are working, making sure that they're doing everything you can to make sure they don't have this illness. And is there anything more for the children who might be around the area that also we might be able to do?
On the issue of the wetness, I don't, I'll look to my staff to see if they have any particular expertise on that issue. But my understanding of the cause is dust that's airborne. So if it's the purpose of wetting it is to prevent it from even getting away. So it weighs it down so that it actually can't get into the air. So I think that's probably the answer on that issue. That's the whole purpose of wetting it down so that it doesn't get airborne. So I think that's the answer on that one. And as to the workers, like I said, we're adding some measures to make sure the workers are protected, and through this, and then as to non-workers, through the implementation of this VERA agreement, to make sure that there will be a complete net offset of zero of fugitive dust emissions, because not fugitive dust emissions, but it's particles that are airborne that can be through diesel, particulate, or fugitive dust. That will be fully offset to zero. So the change in condition between sitting here today and after the project is underway will be no change, and that's something that we worked hard with the Air District on to make sure we implement a net zero result for the air quality in the Central Valley, to make sure that the high-speed rail project, which will have significant air quality benefits when it's up and running, but in the near term, while the construction is happening, that the project is not adding any additional increment to the existing air in the Central Valley.
Mr. Hartnett.
Thank you. I have a few questions on the process, the CEQA process, as compared to the process that is separate that we utilize for board meetings and public comments at board meetings. And I want to see if I understand the distinction correctly as it relates to opportunity for review and comment on the final EIR. Did I understand you correctly to say that as to the actual final EIR, there is a certain publication time period required for that before it is presented to us for decision, and there's certain response time in writing to public agencies that is required to the extent public agencies have submitted comments. So thus far, am I correct on that?
Well, as to publication for the board's consideration, there's no requirement for that under CEQA.
Okay.
The Open Meetings Act requires that the board receive materials, and that when the board receives materials, they're available to the public, and that copies of materials that the board is considering at a meeting be available to the public at the meeting. And that has happened here. You received the documents here, and a copy of the EIR has also been outside as well.
Okay, so even the distribution of the CEQA documents, it's not a statutory requirement for that for purposes of our decision today. The distribution of it was made in accordance with their normal meeting procedures, but not as a CEQA requirement. Is that?
That's correct. We went actually beyond the requirements of both CEQA and Bagley-Keene, the Open Meetings Act, in the activities that we did in terms of making it widely available and publishing it, 17 days before today.
Okay. So the in terms of at least the statutory requirements, when people talk about the period of time within which to be able to review and respond as they wish to as to the final EIR documents, that actually the CEQA doesn't require that there be public comment on those documents before they're certified. CEQA doesn't in and of itself. That the purpose of the documents, at least from a CEQA framework, is if we certify it, it provides us the sufficient information for us to make decisions that arise from the CEQA documents. Is that correct?
That's correct, and there is no review and comment, public review and comment period of time on the final EIR. It is for the board's consideration and information.
Okay, and so we have met and exceeded. We certainly have met the CEQA requirements in terms of the public involvement of with respect to the final EIR. In terms of the normal meeting requirements under state law, unrelated to CEQA, we have met or exceeded the publication requirements of our agendas and information thus far. Is that correct?
Yes, on both counts, yes.
And in terms of people making public comment through our normal process, we had obviously quite a few people speak yesterday, many of whom have spoken to us before and who are quite familiar with our with the process of both speaking, that is, making their points within the time allocated. Often it's 2 minutes, but we had extra time of 3 minutes yesterday. And also, there's a right for people to submit, as it relates to our normal board agendas, information in writing in advance of the meeting or at the meeting itself. So we afforded people yesterday as much or more than what is required by the state process that we run our meetings by. Is that correct?
That's correct, and I also just note that in the days leading up to when we and the time leading up to the time when we recessed and closed public comment last night, earlier that day and in the days leading up to that, the authority received numerous written comments and letters from various stakeholders and others.
Yes. And we had a number of attorneys speak yesterday as well on behalf of groups, and of course we regularly receive letters from attorneys making the points that they wish to make, that they understand they may not be able to make in 2 or 3 minutes of an oral presentation, and they're always careful to give us letters. And some of the individual speakers were speaking on behalf of groups that were also represented by one or more attorneys who also spoke and or submitted written comments as well. So it seemed to me that there was a reasonable and fair opportunity for people to address the issues that they wanted to bring to our attention, either verbally or in writing yesterday. And I applaud the chair who, rather than limit public comment to what was published as 2 minutes with discretion to increase it or decrease it depending on the volume, that from the get-go you extended the period to 3 minutes, and so people who had read the agenda would have known that they had the opportunity initially within 2 minutes to make their remarks, but they actually had more time than that as granted by the chair. So I appreciate that you did that, Mr. Chair.
Thank you, Vice Chair Hartnett. Other questions, comments on this point? Just to underscore something that Vice Chair Hartnett was just saying. Mr. Morales used to run Caltrans. If Caltrans were doing a project and they had to certify environmental documents after the draft, would there have been any further public input into it?
There's, consistent with what Jim Andrews said, there's no requirement in CEQA for that, and typically there would not be. As was just discussed, the publication of the documents and taking the public comments here was a function of the governance of this authority and the fact that the authority has a board which has to comply with the Open Meetings Act, not with the requirements of CEQA. So in other, both for state and local agencies that are not governed by a board, they are not required to publish the final or take public comment on them, other than in responding to the public agencies.
Okay. Other questions or comments at this point? Mr. Andrew, did you have other things to present to us?
I do not. I think we, moving on to the next agenda item, this was the staff response, I think, was the first agenda item for today, and I think there's actually a formal next agenda item, so I think we move on to that, and I can present that, but I'll let you formally move us on to that and then new agenda, and then I'll new agenda
that would
item.
require me to have the agenda open in front of me. Okay, so that's agenda item 5. And actually, I think one thing that might be helpful to the public is if I could just take a moment and read a few sentences out of the briefing materials so that you can understand the context of what the board is about to do. And just bear with me for a second. It says, "It is important to note that the purpose of CEQA, which sometimes gets lost in all the procedural discussion, the purpose of CEQA is to ensure the public and government decision makers are informed, and that the decision makers inform themselves through consideration of CEQA documents of the potential environmental consequences of a proposed governmental action. In the case of EIRs in particular, public comment on the draft EIRs helps round out the information going to decision makers. The first step at the approval stage for the board is to certify, if it so chooses, that the final EIR/EIS is adequate as an informational document for the board about the environmental consequences of the project. So that'll be the first consideration we have, is to the certification of the adequacy of the environmental documents. The second and distinct step is for the board to consider whether to approve the project in question in light of the environmental consequences disclosed in the certified document. This step also involves making written acknowledgments called findings about the environmental consequences that will flow from the approval, and requiring mitigation to minimize those consequences. In the case where you can't mitigate, then we would consider findings and a statement of overriding considerations. The findings, statement of overriding considerations, and a mitigation chart called a mitigation monitoring reporting plan are all included in the materials that the board would consider. So there'll be two distinct steps. One is to consider the certification of the environmental documents as an adequate informational tool, and then the second would be, in essence, to consider the approval of the project itself. So I thought that might be a useful guide for the public. Let me look at council, and just if I misstated that in any way, which I hope I didn't, since I think I'm reading your words, please correct me at this point.
You only stole my thunder, but it was perfect.
Okay.
So I would direct the board's attention to draft resolution HSRA 14-09, which should be in your board materials and has been available on the website for a while, and copies have been available for the last couple of days out in the hallways. And as the chairman noted, this resolution is required by CEQA, and I'll go through technically the three components to it here in a moment that are stated in the resolution, but in essence it is the document by which the board states that as an informational document, the final EIR is adequate to inform the board of the potential consequences of a project, this project, if in the next vote you decide to approve one. And it involves three steps, and you can see this on the bottom of the second page of the resolution and continuation over to the third page of the resolution. The first certification the board is making is that the document has been completed in compliance with CEQA. And the second is that the document that's before you, and it is the final EIR that's here to my left, to the board's right, which is the volumes 1 through 6 of the final EIR and all the underlying supporting documentation. The second is that the final EIR that's before you has been presented to the board members and reviewed by you and considered by you prior to through the certification. And the third one is that the EIR reflects the board's reflects the authority's independent judgment, and I'll go through each one of those in a little bit more detail. On the first one, the certification that the EIR is in compliance with CEQA, and you may ask yourself, well, how can I certify? How do I do that? Is the document a perfect document in compliance with CEQA? And perfection is not the standard, and there's a long history of case law that CEQA the goal is not perfection. It is a reasonable job to comply with the procedural requirements of CEQA and to evaluate as best as possible all the foreseeable impacts of a project that is being evaluated in the EIR. Perfection is not the standard. The standard is does it function as an informational document for decision-making purposes? And is it reasonable, and are there feasible mitigation measures that have been required? And the staff's recommendation to you today is that the EIR does comply with CEQA. On the second certification, that the board has been provided with the EIR, that has been done in the staff's opinion in terms of making the document available to the board. It's here, and as we stated in the materials, that was provided to the board, obviously in various means, including notification on the website and sending paper copies of certain elements of the EIR and CDs containing all of the actual EIR documents. And then the third certification is required. Is regarding the independent judgment of the authority. That the EIR is not that you're not rubber stamping some consultant drafted document, and staff was involved intimately in the development of this document, and it does reflect the authority's independent judgment. And I think, as you've seen from the engagement of Ms. Gomez and Mr. McLaughlin, that the authority has been deeply involved in the development of this document. And with that, I'll turn it back over to the chair.
Thank you, Mr. Andrew. So before we entertain any motions on this, I would turn to my colleagues and just ask if there are questions for our council or our staff on this document, on any of the points that Mr. Andrew just made about the three elements of the certification resolution, or any comments that that members would care to make on this at this point. Any questions or comments? Vice Chair Hartnett.
Thank you, Mr. Chair. I have reviewed the materials, and I want to make some comments on the materials on our final EIR. I think each of us brings a certain experience with EIRs with this to this dais, and I over probably the last more than 15 years, I have had regular occasion to review EIRs, and I bring that experience, my own personal experience, in rendering my judgment as to the adequacy of the materials and how they're presented. And in a certain sense, I find our documents no different than any other EIR in terms of it covers that which you're required to cover. Whether it's a big project or a small project, there's some basic elements to each of them. And while ours is more complicated due to the subject matter and the length, the geography, so to speak, it still has to meet that which any other project has to meet. And in looking at the materials, it does seem to me that we have been presented materials that have been prepared in a way that does a more than reasonable job of complying with both the technical requirements that are required under CEQA and beyond that. I believe that the CEQA documents are more than supportable in terms of how they've been prepared and the information they've provided and in the evaluations that have been done. And obviously we've had the opportunity to review the materials, and it isn't the first time we've seen lots of these things when it was published. I mean, this has been evolving for a significant period of time. So we're not novices at reviewing these materials. Some of the materials were new in the sense of they were updated, but by and large, we've had a long opportunity to take a look at these, and including the volume 6 of the letters that were omitted and that were that brought up and I looked at every single one and all their responses, and the comments were generally speaking nothing new. That I'm very appreciative of the fact that people take the time to make the comments both in writing and in person at the meetings. But you know, there are common themes that we hear over the years that you know were reiterated. But so I think we've had a fair opportunity to review documents over time, to hear from staff, and to hear from an informed public, not just at the meeting yesterday, but previously on issues that are germane to this as well. So should a motion be made to adopt the resolution, I'm certainly going to support it, because I think we really are set with these materials to be informed, to make good decisions of our own independent judgment on those things that arise from this and that face us today and down the line.
Mr. Frank.
Echoing and continuing the theme raised by the Vice Chair, I've worked with really countless environmental impact reports and environmental impact statements over the past 40 years. And based on that standard, I think the document that is before us is very thoughtfully and comprehensively done. This process has been underway, this document has been underway since 2011 and has been pointed out. Actually, the process itself started long before that, back in 2005, as part of a program, EIR, and this has been the kind of tiered process that CEQA and the law and the regulators strongly encourage be pursued. So I think in that sense it's a model of the process being done the right way. I also think the process has been open, transparent, and very inclusive, and for that I think our staff deserves particular commendation for the outreach and in terms of the procedure, going the extra mile beyond the four corners of CEQA's procedural requirements. And I'm sure I speak for my colleagues in additionally wanting to thank the really hundreds of people, property owners, stakeholders, and interested observers who participated in this process either by providing written comments or oral testimony or both. The last thing I'd point out is there was some discussion yesterday in the testimony that the document is quite lengthy and technical, and I think that is true, but we have to remind ourselves that this is similarly a very large and important project and a complex project, and I think the board and its staff would be justifiably criticized if we'd given short shrift to the environmental analysis. In other words, I think the level of documentation and discussion is congruent with the complexity and importance of the project. And finally, I would say that as someone who values plain English, I think some of the technical appendices are slow going for me, but I think the basic documents were written in very accessible prose, which I think is particularly important in light of the second overarching requirement of CEQA, not just to inform the decision makers, but to allow the interested members of the public to participate in a very meaningful way in this process.
Thank you. Ms. Shank, had you raised your hand?
Yeah, thank you. Make sure this, can I be heard?
Yes.
Okay, well, first of all, I want to thank the staff, the public, my colleagues, past and current, and especially you, Mr. Chairman, for leading us through this tremendously complex and arduous process. I can't think of anyone else who could have done it better, so thank you. When I first brought the notion of high-speed rail to Governor Brown in 1981, I guess we were not only young but naive. We really thought that this spectacular state of California would lead the nation in adding high-speed rail to our systems of transportation. Well, I guess the seasons have come and gone, decades have come and gone, and I was thought of as the mother of high-speed rail. I guess I'm now the grandmother who had, but that's okay, I'm still here. Other countries have built systems. In fact, many of them are their second and third and even fourth generation. And here we are. But, you know, I don't want to dwell on the past and should we have done this sooner and should we have had this sooner. I want to sit here in Fresno and look to the future and the future of those young people who came before us, both yesterday and in the past, and the generation that they represent. And I feel a tremendous obligation to them. And so for the people who asked us to delay this yet again, and I thought about it very seriously, but you know, in the past I've been known to not agree with colleagues, to vote against certain proposals. But in reflecting deeply on this, I see no basis on which to delay any further. The record of this process, as was pointed out, began not on April 18th, as some of the speakers would have us believe, but began years ago. The record has evolved, and I agree with Rick that the ability to read it has become much easier. The initial drafts were a little bit more technical, a little bit hard to understand. The staff listened and wrote it in as plain English as is possible. And while it looks voluminous sitting there, and it is voluminous, for those who insinuated that we have not read this, I tell you that you are wrong. We have, and we've read your letters. We've read the responses. Did we memorize every part of it? No, but we did absorb the kind of information to allow us to make a very important decision today. And you know, the staff has recommended to this board, and the board has in the past granted a lot more leeway, and as it should have, because of the enormity of the project. In the draft EIR, EIS scenario, we gave far more time than was required by law. And while some of us may still have a question here or a question there, they don't rise to the sufficiency to impose any more delay. And so when the motion will be made, I will, with a very happy heart, support that motion, Mr. Chairman.
Thank you very much, Ms. Shank. Any other questions or comments at this point? Yes, Ms. Perez-Estalon. Did I miss someone?
Who, me? Yeah, okay. I'm just trying to be considerate. I do have some questions. Yes. I do have some questions, and actually it was a year ago, a nice person reminded me, it was a year ago that you were appointed and sworn in to this board here in Fresno, April of last year, and it's now May. But the point is that in the year of being involved with this project, it has been important to me to raise questions and ensure transparency and to be clear about why we do what we're doing so that that is within the public domain. So before I share my opinions about the secret document and what we're about to do, I do have some questions. In advance of today's actions, I wanted to take a tour of the corridor. I thought it was very important to do that, and so I did that along with a colleague, and it was important for me to experience the corridor because you get a different sense of what's happening on the ground. So there's a few things. One, in terms of the socioeconomic disadvantaged communities, there's a lot of good things that we're doing. There was one particular project that was stunning to me in the community of Wasco. It's a public housing project, and perhaps I should have asked earlier, but it was something that was, to me, a glaring concern. And so I'd just like to ask, about that project. What are we doing to assist that community and about that particular before I raise other questions?
I think on this one I'll turn it over to Ms. Gomez because that's something we have considered in a substantial amount of detail, and Ms. Gomez will cover that.
Thanks. And just for perspective, I think this was a public housing project, and it was of great concern to me to see young families next to, I think it was a coal
Yeah, a coal plant.
A coal plant. Yeah.
So within the city of Wasco, most of the residents live west of the current existing tracks. There is one housing authority that is left, well, it's on the east side of the tracks. So when we come through there with our project, one of the questions was, will we further be dividing the housing authority from the rest of the city? We have been working with the city. The city, along with the housing authority, does have a solution. They have acquired property on the west side of the tracks for relocation of the housing authority. And this will then help the housing authority in a sense. They will be on the same tracks where all the businesses are, the schools, as long as, well, in a sense that within the community. And we are working with the city to assist them in helping getting the housing authority relocated as part of our mitigation efforts. We would have to mitigate in terms for noise and also in terms of the environmental justice. So we think that by assisting the city with a solution that they have already started, we will assist with that issue.
To add a little more refinement on that, I think in essence what we've concluded is the EIR has its conclusions about that particular project and has mitigation for it to ensure impacts are reduced across a couple of different disciplines, noise and other issues. And I think what's been developed, which is from what Ms. Gomez said is a great result, is we can, in essence, and CEQA allows mitigation measures to be swapped out after the project is approved, as long as the mitigation measure that's new mitigation measure that's done later is equivalent or better than the one you already had. So in essence, what is being worked out with the city of Wasco is, in essence, if it works itself out, we'll be able to swap out a mitigation measure of actually working with the city to move it, instead of doing sound walls and other things to keep it in place for no additional cost. So it's a result that allows a better result than the EIR came up with, which was, and the EIR did not conclude that it was an issue to begin with, but this is a better result and won't cost any more money. And that's what's being worked out.
And that's the kind of stuff that I'm excited that this is allowing us to do. I come from a farm worker family, and I may not be a farmer, and I'm not a chemist, but and I'm not an engineer. But it was actually it was very eye-opening to see kind of the activities, the moving of soils and the tilling of the fields and everything that's going on, and they just like what's already there and the challenge that we face in terms of building this project in the midst of a lot of different conditions. And so what I'm excited about is that we can do this in the most environmentally responsible and sensitive way and ameliorate the conditions of some folks significantly. And thinking about the young folks, the young kids that I saw there that have to live with these conditions. And so I'm excited about the opportunity to improve their quality of life, and for me to understand that by approving the CEQA document and by supporting everything that we've done, to know that we have reached out to communities and to property owners and to neighborhoods and every organization that we can to hear their concerns, address their issues. And I really want to say thank you to the team, to our staff, as well as to the cities that we're working with and in partnership with them so that we can together do this project. So I don't want to get on my soapbox. I just want to say that spending time on that corridor really helped me appreciate just what we're trying to do and the environment under which we're doing it.
Thank you. Ms. Selby.
Mr. Chair, I was the colleague who was on that trip, and this is actually my third trip to Fresno, the area of Fresno, in the last month and a half. And I want to focus on the Part C of the certification about that this document reflects the authority's independent judgment and analysis. And I have to say that I have received numerous briefings by various people, from Tom Falens to Jim Andrew to Mark McLaughlin, to try and get me to understand this document, and I'm highly appreciative of the amount of time they took. Time sometimes on the weekends I met with people, sometimes after hours, sometimes teleconferencing, and I really appreciate that. And I must say, I feel very much that the staff of the authority owns this project. They get it. They are emotionally engaged in what it's all about, and they're doing their best to make that happen. I want to thank Diana Gomez specifically for taking me around the project twice. She met with me on 2 separate days to have me look at Madera to Fresno and then Fresno to Bakersfield. And it is eye-opening. It is, I think it's absolutely important to meet with people who are getting their properties mitigated. We met with one person who was moving from one spot to another, a barber who had been there for 30-plus years. And then we met with a gas station that may or may not be moving. And both of them, it seemed to me, were being treated well, that they understood the process, and that they felt like they were being treated fairly. So that was great for me to see. I want to finally just thank, obviously, the people of the Central Valley who have been coming to these meetings, as my colleagues have said, for their passion, obviously, for the beautiful Central Valley, and for spending the time to help inform this project. I am convinced that this project would not be as good as it is, and that the document that we're looking at today would not be as good as it is without all of the contribution of all of the people who have taken their time to add to it. So I thank you.
Thank you, Ms. Selmy. Vice Chair Richards.
Thank you, Mr. Chairman. I'll just make this short. First of all, I would echo most of the comments by my colleagues. Over the years, I have been involved in a number of environmental impact reports and studies, generally as an applicant. The one thing I've come away with is that generally the EIRs and the process don't change people's minds. So it's not without any expectation that the document itself didn't necessarily turn people who may have been opposed to this project to people who are in favor of it. But when you think about it, that's not really the role of an environmental impact report and the process. The process is to ensure that we have adequately and according to California law studied the environmental impacts of a project. And it's clear to me, at least from my experience with a number of others, none as complex as this, none that has been under process as long as this, that this is head and shoulders beyond any that I have seen. Maybe it ought to be because of the scope of this project. But I particularly agree with my colleague, Member Schenck. I can't imagine comments that would be appropriate or would be expected, perhaps they'd be appropriate but expected, that by delaying this process would cause a change in the environmental results or the conclusions made in the document. And so with her, I would, if the motion is made, I would certainly support moving forward with the certification of this environmental report in EIS. Thank you.
Thank you. I'm going to reserve comments for the next item, but before we entertain a motion on this, I just want to echo what my colleagues have said in thanking all the staff members, the consultants. Mr. Morales, you're the leader of the staff. Ms. Gomez, you're the leader here in the Central Valley. All of the people who've worked on this, some of whom we've heard from, many, most of whom we've not. And I would just say that given the comments that have just been recently made by my colleagues, I think what we've seen in these documents is a very high degree of professionalism, and you have our gratitude for that. So, thank you. At this point, I think comments having been made, I'll entertain a motion on the resolution before the board for the certification of the California High-Speed Train final environmental impact report, environmental impact statement for the Fresno to Bakersfield section.
Mr. Chairman, I would so move, specifically including each of the 3 specific certifications contained on pages 2 and 3 of the draft resolution as outlined by our council.
Second.
It's been moved by Board Member Frank, seconded by Board Vice Chair Hartnett. Would the Secretary please call the roll?
Ms. Schenk? Yes. Vice Chair Richards?
Yes.
Vice Chair Hartnett?
Yes.
Ms. Perez Estelano?
Yes.
Mr. Frank?
Yes.
Ms. Selby?
Yes.
Chairman Richard?
Yes. Thank you. Before we move to the next item, well, should we, I guess the question is, should we take a break now, or should we let me just ask the court reporter. Court reporter, for the record, gave us a thumbs up, so we're good. The record will reflect that. Mr. Andrew, did you want to make any comments before the next item on the adoption of the project resolution itself?
No, I do not. You summarized the two-step process, and we are now at step 2.
All right. Before we go on to that, Vice Chair Richards, did you want to, I think you had some issues or concerns you wanted to add to this resolution?
Thank you, Mr. Chair. With regards to resolution number HSRA 14-10, I would ask staff to amend that resolution, which we will act on shortly, to include the following changes. The first change would be to add to the end of the 5th whereas clause the following: and the authority will not approve any construction south of 7th Standard Road without providing the City of Bakersfield with at least 60 days written notice. And the second change to the resolution, with the approval of my colleagues, would be to amend to address Valley Fever, and amend Exhibit A to require as an additional required design feature for the construction safety and health plan in the final environmental impact report, section 3.11.6, the 4 items listed on page 1 of the staff response document dated May 7th, and which Jim recently reported to us in the previous presentation on the previous resolution.
Okay, thank you very much, Vice Chair Richards. I think both of those, to address both the request by the City of Bakersfield and further elucidation of mitigation measures on Valley Fever, are responsive to questions. Mr. Andrew, did you want to make a statement at this point?
Just briefly, just to remind the board of, reiterate in a little bit finer detail exactly what we're doing, what the board is being requested to do right now, which is approval of the project. And as the chair mentioned earlier, part of that involves, I guess I would call it sort of staring in the face of, by adopting the findings of what the impacts are of this particular project. The impacts and mitigation measures are in the EIR that you just certified. Those have been brought forth in Exhibit A to the resolution, which is findings of fact where the board is acknowledging the impacts of the project and the mitigation measures that through this resolution will be required to mitigate those impacts. So this is a piece that comes from the CEQA document but is related to the approval itself. And I think what's important about that is that the EIR EIS document goes all the way from the Fresno station to the Bakersfield station. The staff recommendation, as you've heard, is for approval of the project for now, just as 7th Standard Road in outside of Bakersfield for the reasons that have been discussed over the past 2 days. The CEQA findings that are part of this resolution are only making findings about that particular part part of the project. That's how the CEQA process works. You are making findings about the impacts of the thing that you are going to approve. So that's what the findings actually contain. And then the second part is on a project like this and many projects, not all impacts can be totally eliminated through mitigation measures. And so what CEQA requires is that the board acknowledge remaining impacts that cannot be mitigated, and then weigh and balance those impacts against the benefits that the project would produce, and adopt a statement of overriding considerations that for reasons of the benefits, that those benefits override the impacts that cannot be mitigated. Because there's no feasible mitigation to mitigate those impacts, you have to mitigate first where feasible. And if you cannot mitigate because it's not feasible, or there's just no technically available mitigation, the CEQA says decision makers have to acknowledge those and specifically weigh and balance the benefits of the project against those remaining impacts. And that's what the Statement of Overriding Considerations document, Statement of Overriding Considerations, which is part of the Findings Exhibit A document, which is Exhibit A to the resolution. And then Exhibit B is the mitigation monitoring and reporting plan that the chair mentioned earlier, which is all of the mitigation measures that are part of Exhibit A are reiterated in a sort of tracking format to make sure that they're not lost, that we have charts and columns about who's going to do it, when it's going to be done. It's an implementation tool so that the requirement of mitigation is not just a paper exercise that gets lost through the implementation of the project.
Thank you. Just before we go on, and I have comments that I want to make, just on this last point, these two items that Vice Chair Richards put forward here, if there are any questions or concerns on that. They strike me as both highly appropriate. So, okay. Well, with that, and having certified the environmental impact report and the environmental documents, we now come to what is in essence a vote on the project itself. And I have a few comments that I'd like to make at this point. First and foremost, people in public life often spend a lot of time congratulating each other, and I suppose the public gets weary of it, but I can't go any further without saying how profoundly honored I am to serve with this group of women and men. They're very serious people. They take their responsibilities seriously. I think you've seen that in terms of the diligence with which they've approached these very complex matters. Some of our newest members taking time out of their lives to travel the entire alignment. It's just a wonderful group of people who are very public-minded, and I'm just honored to be a part of this. Speaking of that, when you sit where we're sitting, you have the weight of public responsibility to make decisions that are going to have some impacts or effects on people's lives. And that's always a difficult thing, because I think most of us sit here and think that the construction of a high-speed rail system in California, which was called upon by the voters, called upon by the legislature, and the people of California, is a good thing for the state. Most of us believe that. All of us sitting up here, I believe that. But we are not blind to the fact that that cannot be done without having some effect on individual lives. And you know, I have seen this firsthand. Like my colleagues, I've traveled throughout the valley. Ross Browning spoke yesterday. Mr. and Mrs. Browning were very gracious in hosting me in front of their home in Kings County. And Mr. Browning said, "Listen to this." And he stopped and he said, "The quietness is why we moved here." And they're facing a potential overpass that would have some, could affect the economic value of their property and their lifestyle. I have stood on Frank Oliveira's farm, looked at his cherry trees, and when he asked me the question of how am I going to be able to work both sides of this with the alignment coming through. I have traveled with the Fukuda family, seen their son's Aaron's home in the Ponderosa Ranch subdivision, which would be impacted heavily with an alignment that comes through there. I've stood in the milking barn of Sam Gaspar, a second-generation dairyman whose family works the dairy farm there. I've stood at the edge of John Toss's property, the chief plaintiff in the lawsuit against us, and seen where the alignment would come. You can't do this and meet these people and get to know them as human beings without feeling a great sense of responsibility for making a decision that might have some effect on people's lives. And it just comes with the territory. It's part and parcel of what we do here. But at the same time, as was pointed out, we have to make a decision about whether or not there are larger superseding benefits and value that this decision would bring not only to this community but to the state as a whole. And you know, in reflecting on that, let's consider a couple of things. You know, we've got another billionaire who, just because he's made a lot of money and successful in business, thinks that he's got a great idea for how the state ought to be organized, who wants to put on the ballot in November a measure to divide California into 6 separate states. Now, consider this. If that were to succeed, where we're sitting now in the Central Valley, the state of Central California that he would create, would replace Mississippi as the poorest state in the United States. It's a shocking thing to contemplate because of the tremendous wealth and success we have here in the agricultural sector, and yet poverty is rampant in this part of California. We heard people yesterday talking about children in Hanford coming to school with inhalers. That's not because of high-speed rail, because there is no high-speed rail. That's because 21% of the children in the Central Valley have asthma, because the air quality in this region is so poor that it violates federal standards, it violates state standards, and something needs to be done about that. We need to look at the future of the Central Valley on the course that we're on right now. According to the experts, you know, and I hear people say to us, well, high-speed rail is going to, one person used the word, destroy agriculture in the Central Valley. I would like to put things in perspective. We are looking at, across this 114-mile segment, about 3,500 acres of agricultural lands that would be heavily affected. And I'd like that number to be as close to 0 as possible. Over the last 40 years, Mayor Swearingen tells us that the city of Fresno, not the county, but the city, converted 50,000 acres of agricultural land to development. In the years between 2000 and 2008, the counties of Fresno and Kings converted 33,000 acres of land to development. That's almost 10 times the amount of land that we're talking about for the high-speed rail line. The experts predict that between now and 2035, 173,000 acres of land, farmland, in the Central Valley will be converted to development if we don't do anything else and present trends continue. And we're looking at, over the next 40 years, up to 10% of the arable farmland in the Central Valley being lost. Now, high-speed rail is not going to counter all of that. But the opportunity to revitalize these cities, to create vibrant downtown areas that connect people's jobs and jobs and living areas, is a great promise of high-speed rail, and something that I really believe, in conjunction with far-sighted leaders such as we have here in the city of Fresno and in Palmdale and other communities in which we're working, can really look to revitalization of these downtowns, and the high-speed rail can be a tool to do this. You know, the state passed Senate Bill 375 by our Senate leader Darrell Steinberg to require communities to coordinate land use and transit planning. I've been told by planners here in the Valley that high-speed rail is virtually the only tool, not the principal tool, but virtually the only tool that they have to drive that kind of more vigorous downtown development. So, yes, there are going to be effects. Oh, and let me also mention, the unemployment rate as we sit here is twice the state's average. In the construction trades, it's 30 to 40%. The opportunity to connect our state is, I think, the greatest benefit that high-speed rail can bring. And I've actually quoted one of the things that I thought was most amazing was when Governor Pat Brown was able to push through the California legislature by one vote, the same margin by which we got through the California legislature, by one vote, the state water project. At the end of that, he called in all his supporters and advisors, and he raised his glass and he said, "Now we are truly one California." And that is something, that's a promise that I think we're here to renew. I just want to add one other point, and perhaps there's a personal aspect on this because I and my colleagues have been called out on this. We live in a time when political discourse, unfortunately, gets polluted by the need to demonize people who are on the other side of issues that we have. It's a natural human tendency, and I understand it. And I also think that people who want to challenge the project for whatever reason would like to try to use as a tool for that, undermining the legitimacy of what we do here. And frankly, I think the statements that have been made by some elected officials and others that we're jamming this process through and so forth lack credibility when you look at the actual record of the lengths to which this organization has gone to be inclusive and transparent. People can have different views on that, but I think the facts are pretty clear. And in particular, I just want to comment on some of the statements that were made by officials from Kings County that said that in this process that somehow we had not been responsive, that we had broken our promises, and so forth. Let's just review a little history. This document would have been before this board several months ago, but I personally asked the board to delay its release in the late spring and the early summer of 2012 because we were trying at that point to see if there was a way to work with Kings County on issues that could be resolved, and we knew that once the document was released, we were all constrained by the formal legal processes. I can't say that either our staff, our council, or our funding partners at the Federal Railroad Administration were thrilled about that, but we did. Unfortunately, it did not result in any kind of positive movement there. We did extend the time. We doubled the time period that people had to comment on this. In June of 2013, Ms. Gomez, I, and several of the other technical staff went to Hanford for an all-afternoon meeting in Kings County. Now, at the time, Kings County was a litigant. They still are a litigant against us. So I can't say that Mr. Falens, our outside counsel at the Attorney General's office, and others were thrilled about the notion of the board chair sitting down in an open public meeting talking with people about issues that were the subject of litigation. But we said, look, we think it's important to try to reach out and do this. And I remember standing there at the whiteboard, drawing pictures of I-5 and maps of Highway 99 and explaining to people exactly what the thinking was about why those corridors had in fact been rejected in the earlier environmental analyses. So I know that we went through all those issues. Today, Kings County is not allowing us onto public lands, not private lands, but public lands, to do soils testing or other things that would be important for us as we move forward with the project. That issue, unfortunately, is going to have to be resolved in court. So I reject the notion that this board and its staff has not reached out to any part of this Central Valley in trying to move this project forward. And in fact, I just want to close with this. Sherlock Holmes had his famous story that was predicated on the clue about the dog who didn't bark. Let's talk for a moment about the people who did not appear yesterday to raise issues with what we're doing. I did not see state agencies like Fish and Wildlife or other departments of our Natural Resources Agency come here and say, you have not adequately considered these issues. You're leaving concerns out. I did not see environmental groups come and say, we have grave concerns about what you're doing. In fact, the American Lung Association came and said, we basically support what you're doing. And with one possible exception, I did not see groups from the agricultural sector, as we had, frankly, when we did with the Merced to Fresno EIS, come in and say, you've totally blown it, you've misunderstood the impacts that you have on agriculture. In fact, to the contrary, we were very gratified that some of the biggest agribusiness concerns in the southern San Joaquin Valley came in and said that they appreciated the alignment decision, but also I remember hearing Ms. King say that they appreciated the fact that we had brought into this process the mitigation measures that were part of a settlement in the earlier alignment, and that that was going to have a beneficial impact on agriculture. And so here's a narrative that maybe you're not really seeing in the newspapers. And that's no knock on any of our friends in the media, but I just want to point out. Yesterday somebody stood up and talked about the fact that in May of 2011 something happened and that it really misrepresented positions to the board, et cetera, et cetera. Well, I wasn't here then. Mr. Morales wasn't here then. Ms. Gomez wasn't here then. Mr. McLaughlin wasn't here then. Many of my colleagues weren't here then. So I don't know what happened then. But I know what's happened in the 2.5 years that I've been on this board. In the 2.5 years that I've been on this board, we have come into the Central Valley, an area that will benefit more than any other part of this state from high-speed rail. An area where there had been a lot of unhappiness up and down the valley, lack of information, inadequate communication, so forth. We settled, resolved all 4 environmental lawsuits, Madera, Merced counties, and the respective farm bureaus. We settled and resolved environmental lawsuit challenges in Chowchilla. We've resolved issues here in Fresno on Golden State Avenue and other places. South of Kings County in Wasco Shafter, we have worked with the affected communities and come up with an alignment that works. Into Bakersfield, we are now working with the city of Bakersfield. The story of high-speed rail in the Central Valley is that over the last 2 years, I believe we've started to write the chapter of how you can bring a major infrastructure project to bear in the right way. Working with communities with sensitivity to their needs and listening to their concerns, and then with highly professional people resolving those. I would hope that we can still do that in the remaining parts of the valley. I have to tell you, I'm not sure that there's anything that we can do that would be satisfactory there. I hope that I'm wrong on that. But I think it's important as we go forward today to say 2 things. This will be a tremendous boon to the valley, and the benefits of this will tremendously outweigh the costs. And the second thing is that this organization is very serious about its public responsibilities. We will continue to reach out to every citizen, every public official, every organization, and try to make sure that this is done in the right way. I'm sorry I went on longer than I intended to, but this is the end of a 2.5-year process. So with that, I'd entertain any other comments or questions from my colleagues, or entertain a motion on the document itself.
Just one quick comment as we move to the merits of this process. Like my colleagues, I listened with great interest to the informed and passionate testimony yesterday, but I confess I was particularly taken by a couple of the people who testified, and they're both local students here. And in my day job, I work with students all the time, so I'm particularly sensitive to their needs. But if I got my notes right, one of our students from the local state universities characterized high-speed rail as, quote, the next natural progression for transportation in California. And another student referred to high-speed rail as, quote, a stepping stone to the future. And I thought those were very thoughtful and cogent comments, and comments that I agree with. And they're particularly resonated with me as I approach this decision.
Thank you. Vice Chair Richards?
Yes, thank you, Mr. Chair. I would thank you, Rick, for the comments. I also was not touched, but certainly moved by a couple of the comments from the students. But one is one that we have echoed over the last several years, and here in the Valley especially with the very often support of our chair. But that was one of the students, I think her name was Bianca Rodriguez. And what she said is something that's really important, and for all of us here in the Valley, we understand this. She said that 2 years ago, it was her intention to get her degree and leave. And now she sees a reason to stay because of high-speed rail and other opportunities that it will bring with it. For all of us who live here, and for my colleagues who don't, we can tell you story after story after story over the last 25 or 30 years about how we have lost the best and brightest in this valley, leaving to other parts of this state and other parts of the country for better opportunities. And so one of the things that I have always thought from the outset, and that we have talked often to groups, high-speed rail is in and of itself an amazing transportation system. But for a valley as large as ours, with as much economic strife that we have and continue to live through, with unemployment far in excess of the rest of the state and the country, and with an entire economy that pretty much has lived on and continues to live on the hopes and aspirations and successes of agriculture, we have constantly had the need to look for something else. That has not happened very successfully over the years, or we wouldn't continue to be talking about it. But there are two things that have happened. One, through development of which many of you know I have spent most of my adult life here and have participated in, and that is removing land from agriculture and other purposes for urban sprawl. In the long term, that doesn't benefit any of us, locally or as a state. What it doesn't do, most of all, is it does not benefit agriculture. Never has and never will. Because we are probably, as a result of the urban sprawl, the greatest perpetuators of the loss of agricultural land. And all the things that go along with it, as the chairman said, 173,000 acres over by 2035. Ag can't afford that. We can't afford to lose the prime agricultural land that we have so readily taken over the last 35 years. That, in combination with an opportunity to do something with high-speed rail that I was saying to the chair of engineering yesterday, Dr. Nueves, you know, the project in and of itself is going to create jobs, and we know how important that is. It's going to have an economic benefit in the near term. We know how important that is. But in the longer term, what I have constantly hoped for and encouraged people to think about is not what we're doing for this specific project, but what are we going to do to benefit the economy of the Central Valley for more than just the construction period. Because it is, I've often thought, it's just like Coca-Cola. As hard as Pepsi and other soft drink manufacturers have tried to succeed or to exceed its success worldwide, when you're first out of the block, it's very difficult, if you do your job, to be beaten. And that's what we have an opportunity to do here. We have an opportunity not just to be on the leading edge of constructing high-speed rail, but learning how to develop it and learning how to make it better. And that's where organizations, institutions like Fresno State and the other universities and state universities up and down the valley are taking the benefit of adjusting curricula to provide the kinds of training for the young people coming up so that there are opportunities here not just to be involved perhaps with high-speed rail and other technology, but to make it better, to be leaders in the movement of high-speed rail across the state and across the states of the United States. So the opportunities here perhaps aren't akin to the aviation in Southern California 50 years ago, but it is the best hope that we've had as long as I've been here. And it's the best opportunity for us to share with agriculture and the other parts of our economy how we can in fact improve the Central Valley and quit being called the Appalachia of the West, and quit what you said was frightening to me, and I'd never thought of it, Mr. Chairman. I mean, it's foolish to think we're going to break California into 6 states, but could you possibly imagine how this central part of California, as the most depressed state in the Union, if that was to happen, how would we ever survive? We could no longer live off of the benefits of agriculture. It just wouldn't happen. So and I would only want to say, we're talking about within the agriculture inventory in this four-county area, we're talking about less than 1/10%. I mean, I know one thing about agricultural people. Many of them are my friends, my associates, my colleagues. They're very knowledgeable in how to adjust. They make things happen. That's what ag does. It's why you've been so successful here. It's why you will continue to be successful. That's why together what we can do is we can build an economy in the central part of California that really does give us that opportunity to sit at the same table with a full-size chair as the other economic parts of the state of California. It's why I have no difficulty, other than I feel incredible pain for the people that this affects. But I feel no difficulty, Mr. Chairman, in making the motion for the approval of resolution HSRA 14-10, California High-Speed Train, Fresno to Bakersfield section, adoption of the CEQA findings and fact and statement of overriding conditions, adoption of mitigation monitoring and reporting plan, and approval of an alignment in station location.
And that's been moved by Vice Chair Richards, seconded by Member Lynn Shank, and I'm assuming, Mr. Vice Chairman, that you mean to include the two other items that you previously described to be included.
Yes, thank you, Mr. Chair, as my proposed amendment. Yes.
Okay, so as amended, the resolution is before us. Would the Secretary please call the roll?
Ms. Shank? Vice Chair Richards?
Yes.
Vice Chair Hartnett?
Yes.
Ms. Perez Estelano?
Yes.
Mr. Frank?
Yes.
Ms. Selby?
Yes.
Chairman Richard?
Yes. Thank you all very much for that. We do have... well, you can clap. Thank you. We have two other items on our agenda. I think at this point, why don't we take a few-minute break, and then we'll come back and address those last two items. Thank you. lost my gavel. No, they didn't bring it back. Okay, if I could ask people to reconvene, please, so we can just complete the agenda in front of us. I am gavelless. I don't know. Mistaken. Yeah, right. Okay. Ms. Selby, if I could call you back up here. All right. We have two other agenda items for the board. Item number 7 is an amendment to the financial advisory contract. And Mr. Morales, would you like to introduce this item, or is Mr. Flens going to do that?
I can do that, and then Tom can. These next two items, I think, are significant because they really are reflective of now really moving forward with this program and helping us do that. This first one is for a financial advisor. We have an existing contract in place. We are asking for your approval to go out and procure a new financial advisory contract. It's significant and different than the one we've had in place currently because over the next few years we really are looking at a whole new stage of development of the program and the types of skills and advice that we'll need from an advisor as we look at concession agreements, at operating agreements, at bringing in private investment into the program. So the RFP reflects that. We will use the procurement process to bring on the best resources that we can to help us achieve those goals and maximize the benefit for the state economically as we go forward and put together the program. So what we're asking is to extend the time of the existing contract just to with no additional funds in order to let us implement the actual procurement of the new contract, which we would then look to have in place this fall.
Okay. Ms. Perez-Estelano, did you have a question, or no?
No, I did have one simple question. Just for clarification, because I didn't see it written in the staff report, is that there's an existing contract, there's a total, which has a total value, and that we are essentially just extending the current contract but not extending that final value. So as...
That's correct.
All right. So, and so we're going out an extra 90 days to allow us time to then put an RFP out for put out an RFP out that would include the 30% requirement for small business.
That is correct.
That's one.
Okay. Other questions?
Yeah, Dan.
I'm sorry, Ms. Schenk, yes.
Thank you. Tom Umberg and I were involved years ago in the RFP for the first go-round of this, and we reached out to expertise in some of the other departments, general services and Department of Finance, et cetera. And I've had the conversation with Mr. Flens just to make sure that as we are going forward that our staff reach out to the expertise that is available to us in other state agencies.
Mr. Morales?
Absolutely. We do. Currently, we work with Department of Finance, with all the state agencies. We will, state treasurer, we will continue to do that. The types of concessions that we will be entering into are pretty unique structures, and so we do need external advice on that, but we will certainly continue to draw on any and all resources available within the state.
Okay. If there are no other questions, I'll entertain a motion for this resolution for item 7.
Move adoption.
Okay.
Second.
Been moved by Vice Chair Hartnett, seconded by Vice Chair Richards. The Secretary, please call the roll.
Ms. Schenk? Yes. Vice Chair Richards?
Yes.
Vice Chair Hartnett?
Yes.
Ms. Perez-Estelano?
Yes.
Mr. Frank?
Yes.
Ms. Selby?
Yes.
Chairman Richard?
Yes. Thank you. Okay, the last item is a very important one, which is the memorandum of understanding, the agreement with the San Joaquin Valley Air Quality Management District. Mr. Morales?
Mr. Chairman, this item came up in comments over yesterday.
Right.
We heard some discussion. It's a very important piece of us moving forward with this program, and really of ensuring. It's an important part of our effort to make sure that we see benefits accrue in California generally and specifically here in the Valley. We have reached agreement with the San Joaquin Valley Air Pollution Control District to implement a mitigation program that will provide near-term and ongoing benefits to this region in terms of cleaner air. And it's consistent with the way we've approached other agreements, for instance, the preservation of ag lands in Merced and Madera, where we're working through local agencies, through other agencies, to implement their programs for these benefits. We're working with the local agencies to avoid reinventing the wheel, but also to provide benefits that have been deemed priorities by the local agencies. And so that what that will translate to here in the Valley will be investments in clean technology, things like replacement of diesel irrigation pumps with electric pumps, old tractors and farm equipment with clean equipment. It's being done as part of our mitigation, but it's important to note that these are investments in the Valley and in this community that will provide cleaner air in the near term. And even though it's part of mitigation related to construction, the benefits certainly will go on beyond that construction period. And again, we've worked to develop this with the Air Pollution Control District. We will be funding their priorities consistent with the mitigation needs identified in the EIR that you just certified.
Okay, I had one question on it, but I'm going to defer to my colleagues. Mr. Frank?
Just a couple comments. I'm in strong support of this item. We've heard both yesterday in testimony, and you, Mr. Chairman, mentioned it today, the profound air pollution and air quality challenges presented by the Central Valley, and this is a subject I've been following for many years. And in point of fact, there are some seasons and for some conventional pollutants where the San Joaquin Valley is the absolute worst area in the nation, which is a very undistinguished distinction to have. So I firmly believe that when operational, high-speed rail will be part of the solution, not only here in the Central Valley, but across the state to improved air quality. And I think we have a moral, if not a legal obligation, to make sure that during the construction phase we not make an already bad situation worse. So I think this is a very welcome opportunity, and I want to thank our staff and thank the district and its leaders and staff for coming to this agreement, which I hope is part of a long-term cooperative and collaborative relationship as we go forward.
Okay. Any other questions? I just had one. Mr. Dayton yesterday, as he often does, raised a provocative point, which is just the overall governance of this. So my question for Mr. Morales is, it's late in the day, let me just put this simply. How do we make sure this doesn't turn into some kind of slush fund that doesn't accomplish the purposes for which the money is being spent, and in fact that the dollars are tied to the kind of mitigations that Member Frank was just talking about? So what kind of governance and controls do we have on this?
I'll let Jim Andrew speak to some of the particulars, but this implementation of this will be through a specific agreement executed with the Air Pollution Control District that will lay out the criteria. We will have a specific agreement.
I think it's the mic.
Okay.
Yeah, there you go.
We have an agreement with the Air Pollution Control District that identifies the types of expenditures that are eligible for this, as well as tying it to the impacts as much as possible that were identified in the EIR, so that when, for instance, when they, with funding provided by us, replace diesel irrigation pumps, the intent is to have them in as close a proximity to the project as possible, so that we see proximate benefits. But Jim, if you want to add anything.
Yeah, I think the comment yesterday was sort of talked about it as a payment. How are you going to deal with it by just a payment? And it is not a payment. It is you are being asked to authorize an up to and no greater than value, which is to compensate the district for their actual cost of replacing the equipment to achieve the numerical offsets required to offset the emissions of the project and no more. So there'll be a series of very detailed, and the first one's drafted and will probably be signed within the next week to cover construction package 1A and 1B, 50-page agreement with very detailed controls to ensure that the district, spending the money, and we track actual cost for the replacement pumps and the equipment that's purchased, and we match that on an ongoing quarterly basis with the emissions that are actually being emitted. So there are very tight controls to ensure, one, it'll be actual cost only, and we're matching the reductions that are being achieved to the emissions that are actually being emitted. So from a fiscal perspective, they're very tight controls, and the district gets millions and millions of dollars and spends millions a month to try and improve air quality in the Central Valley through grant programs it gets from the state and federal government, and has a long track record of audits and on how they do this. And we're just going to essentially slip into that existing stream, and all those audits have been looked at by the state funding agencies. So from a controls perspective, we're paying actual cost of what it actually costs to achieve the reduction.
Okay, I appreciate that point. This is my last question on it, and I don't want to beat it to death, but respecting the fact that the APCD knows what's going on here in the valley, just a hypothetical, if they say, oh, we're going to do something in Los Banos at the west end of the valley because the wind flow is from west to east, and that's going to mitigate some of the impacts, and our technical experts say, well, that doesn't really help us make sure that we're achieving the zero net impact thing. What happens if there's some disagreement between our technical people and the APCD over the efficacy of a particular measure?
Well, because of the way the San Joaquin Valley is, it's in essence the bottom of a bowl, and these are for criteria pollutants that cause ozone and particulate matter that's in the air. So it is a basin-wide issue. So frankly, if it's in Los Banos, that would be okay. That would be okay.
So if it's a VOC or nitrogen oxide in the basin somewhere, and they're dealing with it, then we consider that good.
Right. Okay. And they have been fabulously aggressive with us in a good way of protecting the air quality in Central Valley. And so I just want to go on record to thank them for, I'm not sure thanking them is the right word, but acknowledging that they take their job very, very seriously, and they have helped us improve both of our environmental documents, and we look forward to continuing to rely on their technical expertise. They are the experts on this, and we really rely heavily on them.
All right. Any other questions? If not, I'll entertain a motion. Oh, I'm sorry.
I was just wondering, Jim, or
Mr.
Jeff,
Andrew?
how was maybe I missed it. How was what's the genesis of the $35 million number? How was that developed?
It's again, it's tied to the mitigation in the EIR that you
So
just,
it was just on the mitigation schedule in the EIR what the estimated cost of the mitigation would be?
It's actually based on the need to offset certain amounts of emissions and pollutants during the construction period, and then what it will cost in order to do that.
So this is for the entire San Joaquin Valley air basin, so it covers Merced, Fresno, Bakersfield, and portions of San Jose Merced and Sacramento Merced and Bakersfield Palmdale. So it covers the whole air basin. And so what we've done is an estimate of the emissions that all of those components within the air basin, the emissions that will go out, and then the district has a dollar figure that it's a sort of target dollar figure, and historically it's actually been, their actual cost has been lower than it's about $9,000 a ton. So we basically multiplied the emissions times $9,000 and got to a number a little bit under $35 million, and we just used a $35 million number as a cap.
Okay. All right, thank you.
Other questions? Okay, motion? Okay.
Second.
Okay. This is moved by Ms. Shank, seconded by Mr. Frank. And the Secretary, please call the roll.
Ms. Shank? Vice Chair Richards?
Yes.
Vice Chair Hartnett?
Yes.
Ms. Perez Estelano? Yes. Mr. Frank?
Yes.
Ms. Selby?
Yes.
Chairman Richard?
Yes. That completes our agenda.
Mr. Chair, I do have one matter I wanted to bring up just as a disclosure item.
Okay.
Something that I've asked our General Counsel, Mr. Felenz, to do. I asked him this just informally in my capacity as Vice Chair. As you know, the statutory authority upon which we're appointed sets the term for the chair of 1 year without term limits, but it just and it has our terms are fiscal year basis, at least as it relates to the chair. And we have board-adopted policies and procedures that are not a matter of law, but just those things that we've decided to adopt. And in our current board policies and procedures, which were last updated in, I think, early 2012, it sets a term limit for the chair being in terms of 2 successive years. And I asked the General Counsel if they could suggest some language for us to change that policy so that we would not have a fixed term limit for the chair, and vice chairs are also similarly limited, so that we would also not have a fixed term limit, and ask that that be brought to the board for its consideration before at a meeting that would, well, it'd be next month, because your term would expire as chair on July 1st, and I thought the board should have an opportunity to consider. No matter what your thoughts may be on it, the board should have the opportunity to consider that issue.
Okay.
And I intentionally didn't bring it to you in advance. I thought I'd surprise you with it.
Yeah, mission accomplished. Okay. So it's just a request to the staff to bring a matter to the board for its consideration next month.
Yes.
Okay.
Mr. Chairman, staff will certainly be happy to prepare that. We'll add in a clause that says, should you be elected president, there will be a succession plan.
Yeah, that's great. Okay. Well, I think now it is time to adjourn the meeting. So I thank my colleagues and the staff for. I know it was a lot of logistical work to bring everybody here to Fresno, but this was the right place to address these issues. So with that, we will stand adjourned. Thank you all very much.